Well, hey, folks, we're going to try this one more time. Bandwidth has been an issue all day today everywhere in Rhode Island, maybe because everyone is on their phones talking about what happened, I guess. I don't know, here was a busy day at the Supreme Court. Joining us is Calenda. We are at the law offices of Inman and Torgy in Coventry, Rhode Island. It's a beautiful night. And after probably a rough couple of days, if you're one of those folks who supports the right to bear arms, it's kind of a beautiful day. But that's one perspective. Tomorrow we'll be chasing down some of the folks in the red shirts, if you will, which here in Rhode Island the economy is red and gold. But let's talk to Calenda. Chaz, of course, is the host of our show. Calenda, attorney at law. He also, full disclosure, is a candidate for the Attorney General. He served 12 plus years as a special prosecutor in the Attorney General's office now, and he practices criminal law, criminal defense law, as well as a number of other specialties here at the law firm of Inman and Torgy. Chaz, something happened today?
I heard there was a major watershed case at the U.S. Supreme Court. Might have been this case, New York State Rifle and Pistol Association versus Bruin. The U.S. Supreme Court, for those of you who didn't know, we're considering a case out of New York where one applies for a pistol permit who had to show a special need to be able to get a permit to carry that firearm on your person outside of your home. Essentially, that meant most people were not getting permits in the state of New York. The U.S. Supreme Court took up that matter in November. They heard arguments on it. They were briefed on it. And today they ruled that there is a fundamental individual right, constitutional right, under the Second Amendment and the 14th Amendment to keep and bear arms both in and outside your house. And that the tests that the courts of appeals across this country had been using to determine whether or not government regulations on the carrying or use or possession of these firearms, the test, whether or not that was an appropriate test. The Supreme Court said the tests that the courts of appeals have been using were not appropriate. They were too deferential to state legislatures and too deferential to state laws. So we have a landmark case here in the Second Amendment jurisprudence that has essentially extended the fundamental right to keep arms in your home for self-defense to outside your home for self-defense with very, very few exclusions.
Now, if you can, now I understand you practice predominantly in Rhode Island and Florida, but how does this apply in general to other states like Rhode Island?
So Rhode Island has a very similar statute. When you apply to the Rhode Island Attorney General's office to get a pistol permit, Rhode Island law states that you must show a need to have that permit, and that need has generally been interpreted to be above and beyond the need of a generalized individual. So you have to have already been the victim of a crime, a target of a crime, or target of violence. And generally, the Attorney General denies a lot of these permit requests. And even on the local level, when you can apply to your city or towns, because Rhode Island has a hybrid kind of system, there's a suitability clause for the towns. And although it's a shall issue on the town level, meaning that theoretically, if you meet all the objective criteria to get that permit, you should get that permit. There is a suitability clause which has been used and abused many times by many different cities and towns throughout the state to deny people permits. That suitability clause has never truly been defined by law or by our courts. The court today, the U.S. Supreme Court today, has basically said that cannot be a subjective standard. There has to be, if you're going to license, it has to be objective standards applied evenly across everybody, and any regulations or restrictions have to be deeply rooted in American history.
Now, we just passed, and as many will note, in a private setting, a law was enshrined, a series of laws, that were controversial, rushed by many accounts into law as a result of tragedy. It is a contention. This is the editorial perspective of the Coalition Radio Network. I don't project onto any of our hosts or any of our shows, but it is the contention of the Coalition Radio Network that tragedy is never a good cause behind, stimulating of, projecting to public policy. Tragedy should be dealt with, internalized, and reflected upon before one jumps into these laws. So that being said, first of all, how bold is this ruling? In terms of, well, let's just go back a few years to a prior court ruling. How more provocative is this?
Well, I mean, on a scale of 1 to 10, where 1 would have been a complete denial of the petitioner's rights to get that permit, and 10 being basically elimination of all regulations that deal with firearms, this is probably close to an 8 or 9.
Wow.
It says this is on the scale. This is a watershed case. This is a landmark case that will be talked about from now until I'm long gone, when you're long gone. This is one where if you're a Second Amendment supporter, and actually if you're just a supporter of the Bill of Rights in general, like I am, this is one where you have to stand up and say the Supreme Court got it right. Because for far too long, the Second Amendment has been treated as a second-class right within the Bill of Rights. Justice Thomas notes that, and he says he is aware, in the court, the majority of the Supreme Court, 6 of them, 6 justices, agreed that the Second Amendment has been disfavored up until this point. That is no longer the case. They said they are aware of no other Bill of Right that has been treated as dishonorably as the Second Amendment has been treated over the years. In this case, purports, and I probably will, make it much more difficult for states, governments, any authority figures to restrict the right of the people to keep and bear arms lawfully for self-defense.
So let's go down, since our audience is, for at the moment, primarily Rhode Island based. Let's talk about these recent laws and what impact. If you just kind of lead us through a list of where you see this law impacting, because there's been this tidal wave of legislation here in Rhode Island over the last 3 years, the last 2 years in particular. So where's the impact on the home front here in Little Rhode?
Well, given the fact that now the court has rejected the Court of Appeals intermediate level scrutiny of government regulations on the core right of the Second Amendment, which they've held is to for people to be able to have and possess firearms in common use for the purposes of self-defense, they have rejected the Court of Appeals intermediate level of scrutiny. They have basically said the government has the burden to prove affirmatively that any regulations they put on the use of firearms or the possession of firearms or arms in general must affirmatively be tied to historical precedents. In other words, these restrictions have existed always throughout American jurisprudence. That's a pretty high standard. That's about as close to strict scrutiny, which is the highest standard that you look at under the law when interpreting a governmental restriction on a constitutional right. So that's going to affect, in my opinion, the magazine ban restriction that just passed through the General Assembly and with much celebration signed by the governor. Many of these magazines that are manufactured with some of the most commonly owned firearms that are in existence in the United States today are more than 10 rounds. Many of them are 15, some of them are 17, 20. You're going to have, right now in Rhode Island, it's a felony to possess those. But a lot of those came with those firearms, so you're effectively making those firearms illegal to possess if they cannot be used safely with other magazines that are 10 rounds or less. That, to me, is going to be a core burden, an impermissibly core burden on this fundamental Second Amendment right to keep and bear arms. And I think that one of the law firms, Kelly, Sousa, and Parmenter, had just announced today that they're imminently filing suit against that particular law that was just enacted. And I think that I know there are going to be other groups that are going to go forward with that lawsuit, also challenging the constitutionality of that law in light of today's decision.
What about public carry? What does this say, or how does this impact public carry, particularly of long guns?
Well, the long guns, it really makes no difference. The Supreme Court did not differentiate between long guns and concealable guns. So the same restrictions that the court has put in place on the government to be able to restrict your use of getting a permit are going to apply to any kind of regulations that would apply to carrying a long gun. And again, the government's going to have to affirmatively prove with a heavy burden over their head that these are long-standing restrictions. Things like keeping guns out of the hands of felons, convicted felons, people with diagnosed specific mental illnesses. Those are the types of things that will probably withstand the scrutiny, but there are going to be a lot of these other restrictions, like the magazine restrictions, the carrying of long guns in a non-threatening or non-dangerous manner. Those are going to be things that there's going to be a potential problem for governments to be able to uphold those now under the jurisprudence that have been given to us by the Supreme Court.
Wouldn't it have been wise for the state of Rhode Island to wait until after this decision before issuing and quite frankly, engaging in a highly politicized, divisive manner?
Absolutely. I said that weeks ago. I was at the State House when the House was considering this, when the House was considering these bills. I said it, I think it was on the Coalition Radio Network. I said it would be wise for the General Assembly to wait, because we knew within a couple of weeks this decision was coming out. And it could have wide-ranging implications, which it does. I advised them that they should wait to find out whether or not these restrictions they were going to pass were going to pass the constitutional level of scrutiny that was going to be applied by the court. Now, I understand why the General Assembly didn't want to do that. They want to go out there, pass their bills, make their constituents happy. Hey, look, we're trying to do something. It's that conservative Supreme Court that's stopping us. So they don't care one way or the other. The one who did have a responsibility to advise everybody, being the government's attorney, the main attorney here in Rhode Island, is the Attorney General. Peter Nerona should have been saying, as the Attorney General, I would advise that we wait and see what the U.S. Supreme Court, the highest court in our country, whose decisions are binding on every single one of us, let's wait and see what they have to say before we jump right into this and subject the state to the multitudes of lawsuits that they are now going to face.
If you were a cynical man, would you suggest or perhaps even ponder the notion that they pass these laws for political gain, knowing that many of them would be thrown out?
I think that probably wasn't even a consideration of theirs. I think they wanted to do whatever they wanted to do. This is clearly what they wanted to do, given the procedure they used in the Senate to bypass a defeat in committee, to put it on the floor and just vote affirmatively for it. So I don't think they cared. I think they said they want to, like in all politics, they're doing this to please the loudest group of their constituents, which is in many cases the people you see with the red shirts up there at the state houses. And that was obvious. If you needed any evidence of that, it was very obvious with the private bill signing ceremony that was done with the governor and only the people who supported the laws. So I don't think they really necessarily cared whether or not what they were doing was legal, constitutional, whatever. They're going to say, here are the laws, we're going to pass them. We have an attorney general that's going to defend them no matter what. So have at it. And that's exactly where we're at right now, because the attorney general has already said he's going to defend these laws. And I guarantee you, until a court tells him to stop, and maybe even not then, until a court tells him to stop, he's going to defend these laws and prosecute them with vigor.
It's already being said in some corners that this decision is essentially the homecoming celebration for one Justice Clarence Thomas. Maybe you could highlight some of the more remarkable aspects of the decision. I assume, and again, one of the reasons why we enjoy our conversation with you, by the way, if you're just joining us, Chaz Calenda, attorney at law, is taking a very special episode. We're at the law offices of Inman Turgey in Coventry, Rhode Island, where he practices law now. To jump on this news, he's already read the 135 plus pages in the decision. So we're just kind of catching up with him. But talk to us about Clarence Thomas's decision, what he's written, his opinion, and some of the more interesting points.
Well, Justice Clarence Thomas has been saying for years, mostly in dissents, that the Supreme Court is not paying enough attention to the Second Amendment, which was baffling because you would never say that the Supreme Court would not pay enough attention to other rights like the First Amendment, the Fourth Amendment, the Fifth Amendment, the Sixth Amendment. All those amendments, they all get special treatment, but the Second Amendment was being ignored. So he finally got his opportunity to author this majority opinion, and he was very direct. And I think I don't want to use words that he did not use, but I think that the final pages of the opinion of the court say it all. I mean, it essentially. Well, I guess I am going to improvise a little bit, but essentially he said it is a fundamental constitutional right to bear arms outside your home for lawful purposes with firearms or arms that are in common use. It does not get clearer than that. They said there are something like 400 million firearms in circulation in the United States. More than half of them have magazines that are by design carry more than 10 rounds, manufactured that way. To come out with such a broad statement and explicitly reject every court of appeals standard of that they've been using to judge these Second Amendment cases, I mean, for Justice Thomas, I think this is probably going to be the case he's probably most remembered for. Just like Justice Scalia, the late Justice Scalia was remembered for writing the initial majority opinion in Heller, which was the first landmark Supreme Court case on the Second Amendment in 2008, which found that there was a fundamental individual constitutional right to keep arms in your home for self-defense. This extended it to outside the home. So this has been, and he also clarified the standard that courts should use going forward when reviewing regulations, which is not a forgiving standard. That standard essentially is as close to strict scrutiny as possible. So he has written an opinion that will be talked about for generations.
Wow, it was a 6-3 vote. We can bet that Justice Sotomayor was probably dissenting.
She did.
And were there other powerful thoughts, or was really Clarence Thomas taking the lead on this in terms of the 6 Supreme Court justices who decided today would be the rebirth, if you will, of the Second Amendment in the United States?
Well, I mean, Clarence Thomas certainly took the lead, but Justice Alito, in his concurring opinion, really ripped apart the dissent, which was written by Justice Breyer and signed on to by Justices Kagan and Sotomayor. He really went to town on them for using the tragedies to justify the restrictions of a constitutional right. And I think it's notable, for those of you who want to read the opinion, the concurring opinion by Justice Alito, to see how detailed he gets in taking to task the dissent on their view that it's okay, based on these tragedies, to infringe on a textual constitutional right, not one that's been decided by a court, or put in there by a court at some point in time. This is our Second Amendment to our U.S. Constitution. But I think it's the most powerful paragraph here, and I did find it was at the very end, is that the constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise only after demonstrating to some government official some special need. That's not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It's not how the Sixth Amendment works when it comes to the defendant's right to confront witnesses against them. And it's not how the Second Amendment works when it comes to public carry for self-defense. How much more clear does it get than that? There is basically no wiggle room in that at all.
And that, in a sense, is the prevailing theme, if you will, of today's Supreme Court opinion. It brings to mind images. If you were to take our rights and place them in a museum, for a generation or so, the Second Amendment was in the kind of that back closet, stuffed away with an empty room and, the whole living, breathing. Yeah, that whole notion of, well, they were writing about muskets. That's over now, isn't it?
Well, it certainly is, because that was over in Heller, but nobody wanted to acknowledge that, because they dealt with that in Heller. They said arms at the time, the right to keep and bear arms, was not limited to arms that existed at the time of the ratification of the Second Amendment. So we already dealt with that. So we're not dealing with muskets. But, I find it ironic that the people who advocate for the Constitution as a living, breathing document are saying that, oh, no, the Second Amendment only applied to the arms that were in existence during the 18th century, with the time the Constitution was ratified, because that would be completely in opposite of what they're advocating normally. They want to say that we should be interpreting the Constitution as a living, breathing document. Well, that's not how you do it, and that's not what's happening here. So that situation was settled in Heller. This just reinforced it today.
So am I being too direct, too blunt, perhaps too strong to say that this decision is in part a repudiation of the notion that any written constitutional right can somehow be shuttered away, measured upon, thought about, conflated, redesigned, reimagined? Is this finally put to rest the notion that our constitutional rights are freestanding and shall not be assaulted?
I think it does a very good job of that. It does an excellent job of that, I would say. I mean, obviously, no right is completely 100% absolute. They've acknowledged that in other cases, not just dealing with the Second Amendment, but other amendments. But it shows what the government has to go through in order to put restrictions on those rights. And that burden was established firmly today, that it is on the government, and it is a heavy burden. It is not this intermediate burden which is going to defer to legislatures, defer to some government officials who are going to use subjective standards depending on who you are, where you come from, and what your needs are. You do not need any other need to exercise a constitutional right except for the fact that the right itself exists.
Now, we know you have some other commitments tonight, and we appreciate Chaz going to, after a full and rewarding day professionally, spending some time with us. The question weighing in most Rhode Islanders' minds is A, repudiation, B, vindication. But on a practical level, what happens next? Again, we just were feeded to a spectacular event, draped in red, where, we watched our constitutional rights frittered away. 48 hours later, holy cow, all of a sudden, things have changed. What has to happen practically in Rhode Island now when you look at the litany of infractions upon our basic rights, I would say our natural born rights to act in our self-defense? What has to happen to these laws now? Do you have to sue? Does someone have to be arrested for the bill? There's an 18-month window on the magazine bill, allegedly. What happens next? Well, what happens next, it's probably already happened, because according to the law firm that's already taken up one of the cases, they were filing today in federal court for an injunction. So basically an injunction is a court order or restraining order, preventing, ostensibly, I haven't seen the pleadings obviously, but ostensibly preventing the state of Rhode Island from enforcing the laws that would be inconsistent with this opinion. So that would be potentially, they're looking at the magazine law. So that's what the one they're going for. I would say also Rhode Island General Law 1147-18, which is the statute that deals with the Attorney General's issuance of a pistol permit. That is basically void on its face, because it writes into that statute that you have to show some sort of need to get that permit. The Supreme Court, that was right on point with what this case just dealt with. You no longer have to show a need. So I would expect that the Attorney General, when he receives applications for firearm permits going forward, will not be applying an unconstitutional standard to those applications. But I would imagine that that will have to be either done voluntarily by the Attorney General, or the General Assembly itself will have to reconvene and decide whether or not that law should be repealed, or you get a court order requiring them to repeal it or holding it unconstitutional. So those are the things that could happen or should happen. If we had good government and we had an Attorney General who was out for the law and not the politics, these things would be happening on their own without the need for further court action, because the United States Supreme Court has spoken. And we respect the rule of law, even when we don't agree with it. So unfortunately, that's not going to happen here in Rhode Island voluntarily. So that is why you have these groups going to federal court to vindicate the order of the United States Supreme Court. And I just want to remind people, we were a hairbreadth away, as they say, from having an Attorney General for whom all permits would be processed through, weren't we?
Yes, we were.
And could one expect at this point that the legislature would take a deep breath and, now with I believe tonight literally ends the session, to go home and tend to their wounds and rethink this, as well as other organizations that I think, what was the word in the speech, that were practicing not law but good politics and asserting themselves politically around Rhode Island. Asserting being, I think, a kind word for this. It's an astonishing day, isn't it?
It really is. I wasn't quite sure what to expect. I figured it would be a positive decision in light of, for Second Amendment rights, at least in some aspects. I figured that the New York law would not survive the scrutiny, given the poor performance by the Solicitor of New York, defending the law, and the questions and the comments by the justices at the oral argument back in November. I did not know how far the decision would go, and I was somewhat pleasantly surprised by just how far that Justice Thomas and the 6-3 majority of this court went to make sure that this right will be protected going forward from governments like Rhode Island, which has done everything in their power to restrict a fundamental, individual constitutional right.
Wait a minute, I thought the Rhode Island Constitution, what were those words? Shall not infringe?
The Rhode Island Constitution does not have that prefatory clause, unlike the federal Constitution. The Rhode Island Constitution, Article 1, Section 22, I believe it is, says the right of the people to keep and bear arms shall not be infringed. To me, that is more direct than even the federal Constitution. So I would hope our elected leaders will take a step back, take a deep breath, and abide by the United States Supreme Court order today, and abide by the commands of the Second Amendment and our Constitution to not infringe upon this fundamental constitutional right.
Well, thanks again, Chaz. We're going to be looking to you in the coming days, as we are throughout the entire election. Tell folks how you can reach Chaz Calenda, both in your legal world as well as some other pursuits that you may be engaged in right now.
Well, certainly, if you're looking for legal assistance, I work at the law firm of Inman and Torgy, which is at 1500 Newsneck Hill Road in Coventry, 401-823-9200. You can give me a call anytime. I'm also a candidate to be the next Rhode Island Attorney General for this coming election here in November of 2022. You can find out more about me there at CHAS, C-H-A-S, the number 4AG.com, and reach out to me through my website or by phone or by email.
Chaz, thanks again. And you can, we'll be putting this up onto our YouTube page. And a quick ask, if you're happen to catch one of our videos on YouTube, if you could take a moment and subscribe. It's important for independent media to get that sort of grassroots social media support. It allows us a reach that, quite frankly, has usually been in the past accorded to the big networks. And I don't think you're going to see this kind of conversation on the big networks anytime soon. Chaz Calenda is... you can see him on our Facebook page at facebook.com/The Coalition Radio, on the Mighty Mighty Twitter, Coalition_Radio. Chaz, what's your Twitter feed?
It's at Charles Calenda.
At Charles Calenda. And follow him independently there. And there you'll also see repeats of his shows, which it is the best legal show in Rhode Island, bar none. It ranges from political conversations about the law and direct applications of the law, some of them notorious, as is this Second Amendment conversation, others more workaday. One of the best shows we ever did, I think, was the hour or so that we spent explaining your ability and the rights and the recourse you have in using the small claims courts here in Rhode Island. So we cover a wide range of political and legal issues. So it's, in our opinion, it is, in fact, must-see digital TV. Folks, we are the Coalition Radio Network, loud and proud, outrage porn-free, ever so proud to host Chaz Calenda, attorney at law. Facebook.com/Coalition Radio, on the Mighty Mighty Twitter at Coalition_Radio, and of course, the mothership at CoalitionRadioNetwork.com. We'll be back at you tomorrow with more coverage of this. And, Chaz, I may find myself bumping into a variety of politicians tomorrow who will be ever so pleased to see me, as they always seem to be. I was accused in open court today of having been arrested at the Barrington school board meetings. Now, what was astonishing about that, Chaz, was that an attorney made that claim in open court.
Wow. I take it that's not true.
It's not true. They haven't caught me yet. So
There's a word for that.
yeah, it was slander. But folks, take a moment. Chaz Calenda, attorney at law. We'll be back, and thanks for tuning in.